Hey, what's up, YouTube? So I'm coming back at you again with another video, and I was thinking about TIandTIny's situation, and I was thinking about the fact that we don't know the names of the victims, or we don't know who the identity of the victims are, right? So at this point, I know that one of the lawyers, Tyrone Blackburn, has come out and he's actually written a letter to several different prosecutors in different states. And in this letter, he's urging the prosecutors to start an investigation. But in the letter that he provides, he doesn't give the names of the alleged victims. Now, if you want to see a reading of that letter, if for whatever reason you're just joining my channel now and you haven't seen that actual letter or you haven't heard the contents of that letter, you can click this link above and you'll see that, or there should be a link. I hope that I remember to put the link there. But if you click this link above, you'll see the reading of the letter, which talks about the victims in this case, right? I think it's called it's definitely over for TIandTIny Part 3. That's the video in case I forget to repost it. You can find that video on my channel. Now, that's the situation thus far. And as we move forward, I realize we still don't know the name of the alleged victims, right? So this is all starting to look familiar to me. And you guys, you let me know. For those that follow my channel regularly, I've been covering lots of different stories and lots of different lawsuits by that pertains different entertainers. And you guys let me know. Let me know if you're a regular on my channel, let me know if this is all starting to sound familiar to you. And to me, it's all starting to sound familiar. And, I remember when I was growing up, I used to love playing chess. I used to also play football when I was growing up. And what I noticed is that there's a pattern to some of these cases. And I talk about that throughout all these videos. But, nonetheless, you would expect there to be a pattern to any and everything. Everything in this world, well, I won't say everything. Many things in this world have a pattern. And if we start to look at the pattern, we can start to understand them, and we can start to, figure out how to deal with these patterns that, come along. So when we talk about patterns, I'm just going to say a play, right? So in football, you have certain plays. You have the blitz play, of course, where you're just going to, blitz your opponent and try to sack the quarterback. Then you have running plays, you have passing plays, you have handoffs, so on and so forth. And if we transition over and we start talking about chess, chess has different plays at different phases of the game. In chess, there's always something called an opening, right? And that essentially talks about, or it covers the tactics or the strategy. Strategy is a better word. The overall strategy that players will use in the opening of the game. Then there's also a mid-game strategy, and then there's also an end-game, right? So there's 3 phases of chess, and you have these overall strategies, and of course, within these strategies, you have these different tactics. So as we look at those 2 basic things, we can accept that, there's patterns, there's strategies, there's plays, right? There's plays, or however you want to look at it. There's this in life, there's patterns. With war, there's strategies, and with chess, there's strategies, and with football, there's plays, so on and so forth. So when we turn around and we start to look at law, we would have to accept that, there's strategies and there's plays that can be ran in the courtroom, right? And one of the things that I realize is that TIandTIny don't know the names of their alleged victims. And to take it a step further, they could never know the names of the alleged victims up until the point where it's too late. And the reason I say this is because we've already seen this. We've already seen it, right? So one way that you can find out the names of the alleged victims is that, the prosecutor comes and the prosecutor indicts you. And when the prosecutor indicts you, you can go before a judge and you'll have what's called a preliminary hearing. And in that preliminary hearing, there is a chance that your lawyer would have a chance to cross-examine key witnesses in the case to determine whether or not you should go to trial, right? That's the purpose of the preliminary hearing, is to determine whether or not there's enough evidence to go to trial, and you're able to cross-examine some of the witnesses, the key witnesses in this case, to make that determination. Now, it's obviously going to be different in different jurisdictions. It may be different in Florida. It may be different in the United States. But generally, in the preliminary hearing, you get a chance to cross-examine the witness. So if you're indicted, you should be able to have a chance to cross-examine the witness. And at that point, even if you don't win the preliminary hearing, at least at that point going forward, you know who the witnesses are, and you can start to prepare for those witnesses. That's why it's so important to understand who the witnesses are, or to know who the witnesses are, so you can prepare for them. You can start to sit down with your lawyer, and you can sit down going through all the details of your encounter with that alleged victim. I think there's even something in the history of law that talks about secret witnesses and things of that nature. We're going to get into that. Back in the day, there was a chance that you can have these secret witnesses against you, and you wouldn't be able to question them, you wouldn't be able to confront them. And I think in some countries they still have portions of that where you can be reported and you don't get a chance to actually confront the witness. But we're not going to get into it now. We'll talk about that with the Confrontation Clause. But as it regards to the preliminary hearing, you have a chance. Once you're indicted, you can know who the witnesses are, and you can't go out and contact those witnesses, right? But you know who they are, and you can start to prepare for them. And you would think that, this is one major protection that keeps people from essentially lying just to destroy your life, right? And to, have you stuck going back and forth to court, and you never get a chance to question them. You would think that the preliminary hearing is the basic protection. But hold on a second. There's a way that the prosecutors can prevent you from questioning witnesses in a preliminary hearing. And the way it can be done is that it can be done through a grand jury proceeding, right? They can have a grand jury proceeding against you. And with the grand jury proceeding, it has very specific process. There's a very specific process in the grand jury hearing. And one of the funny things about the grand jury hearing is that they don't have to have you there in order for them to initiate the grand jury against you. And you can essentially be indicted without getting a chance to even know who the witnesses are. You don't get a chance to vet yourself in front of the jury, or what's a better way to say that? You don't get a chance to defend yourself in front of the grand jury. The prosecutors just brings these secret witnesses to the grand jury, and then they can present these witnesses to a secret grand jury. So the witnesses are a secret and the grand jury is a secret, and nobody can talk about what happens in that grand jury outside of that courtroom. Everything that happens in the grand jury or the special indictment or special grand jury hearing, everything that happens there is under secrecy. The only thing that comes out of that is whether or not you're going to be indicted. So that's a card that the prosecutors can play. And I actually have a few videos about that as it pertains to R. Kelly. And you can see these videos. Hopefully there should be links above that you can click on. You can go and see grand jury hearings and the law that governs the grand jury hearing, right? So those are good videos to check out. But essentially, the grand jury can be used to circumvent, or it can be used to check, or even take the preliminary hearing off the chessboard, right? So you would think that if someone wants to accuse you, they want to get you into court, then you're going to have a chance to confront them or the witness in a preliminary hearing, and to prevent having a trial to begin with, because if you're successful in the preliminary hearing, then you don't need to go to the trial. You can save yourself lots of time and money and frustration, because you went to the preliminary hearing, and in the preliminary hearing, you've proved that they don't have a case. But with the grand jury, in my personal opinion, they can basically take your preliminary hearing off the chessboard, so to speak, and they can almost force an indictment on you. So now you're forced to go to trial, right? Of course, there's also something called the Sixth Amendment Confrontation Clause, which essentially says that you're able to confront witnesses against you. And I actually have a video about that. Hopefully, if you look above, there's a link to the video about that. It says that you can confront witnesses against you, and you have a right to confront witnesses against you. And that's a constitutional protection. In fact, it's the Sixth Amendment. And essentially, before the United States justice system, when there were the old times, or when before the United States was formed, law, or the rule of law, was basically established as we know it, right? As we know it, the rule of law was established in England. And in England, there was a certain time where you could have secret witnesses against you, and those witnesses, they can go before the king, and they could, say whatever they wanted to say in effort to, destroy you. And then the king's court would go on to prosecute you and basically destroy your life, and you never really got a chance to confront the witness. And the witness could just be lying and making up stuff. You know what I mean? So, well, fortunately, when law is established in the United States, one of the things that happened is with the Sixth Amendment, they created the Confrontational Clause, which essentially protects you from having witnesses come forward in secret, make up all these crazy lies about you just to get you locked up and thrown in jail, right? And you would think the Confrontation Clause in and of itself is enough protection to keep secret witnesses from popping up and basically trying to destroy your life by telling lies and so on and so forth. But you would be wrong for thinking that way. So basically, the Sixth Amendment Confrontational Clause can be trumped by using accusations of witness intimidation, right? They can use witness intimidation to essentially say that, we need to protect these witnesses, and the defendant has shown that he has threatened witnesses in the past. When it comes down to TIandTIny, they could try to leverage the accusation that T.I. pulled a gun on Sabrina Peterson. And they can say, hey, look, he's threatened the witness before, and he's threatened Sabrina Peterson's before, and we believe because of his actions or how he handled Sabrina Peterson, that it's likely that he would threaten the alleged witnesses in this case, right? So these type of arguments can be made to prevent TIandTIny from knowing the witnesses in this case. Now, me personally, I think that would be BS, but I thought it was BS in the R. Kelly case, and it still actually happened. Now, there is a slight difference between T.I. and R. Kelly in the fact, well, not a slight difference, a major difference, in the effect that what they're doing in the R. Kelly case is that they're using his reputation or past allegations that R. Kelly has paid off witnesses. They're using a past allegation that R. Kelly made one of the witnesses in the 2008 trial unavailable so that that witness couldn't testify. I don't agree that any of that stuff is true, but these are the arguments that were made, and they made them before the judge, who basically agreed with them, right? And then they also use the actions of the R. Kelly supporters. Some of us, not me, because I actually tried to warn people not to press some of the alleged victims, but some of the supporters actually went out and they, did some of the things that could be considered harassment. They did some of the things that could be considered internet bullying, and then to top it all off, or to trump everything, you had 3 individuals that was alleged of burning one of the witnesses' car. You had another individual who was alleged to call one of the alleged victims and offer a bribe. And then there was a third guy, but I forget what the third guy did. But I'll try to post that video as well, and you can watch that video, right? So these are the things that happened in the R. Kelly case, and they were actually able to use that to go before the judge and say, hey, look, this is a reason that we shouldn't release the names of the victims in this case, right? So that is something that could potentially happen in this TIandTIny situation, because you already have the accusation that T.I. pulled a gun on Sabrina Peterson. So now it's really just a matter of going through these stories, and once you go through these stories, they're going to try to find other things like that. I'm not saying that they will, but they could, right? One thing that I can actually think of, in the one story where I read the letter, the third video in the series, it's all over for TIandTIny. There's an accusation that one of the employees who worked for TIandTIny told one of the alleged victims that she needs to learn to keep her mouth shut, or something along those lines. They could actually use that to say, hey, this guy is going to intimidate the witnesses. He has the means, he has resources, and we want to basically protect the witnesses. And of course, once this is all said and done, when we look at, again, we're looking at the playbook that's been used in these cases, and one of the other tools that's been used is RICO, right? So we don't know how successful the RICO statute is going to be when it comes down to prosecuting R. Kelly. But if it's successful, that is something, again, they can turn around and they can use in the TIandTIny case, right? So maybe that's the video. Maybe that's another video that I actually need to make, the RICO charge pending for TIandTIny. Stay tuned. And we already have enough accusations to put together the RICO charge, right? So maybe I'll make that video, but I mention it now because that is yet another tool that they can use to say, hey, this guy, it has an organization, and we're afraid that he's going to use that organization to intimidate the witnesses, right? So though these are all legitimate ways that they could basically keep TIandTIny from knowing the names of the witnesses. And there's other videos to watch. I think I created a video called "The Reasons R. Kelly Does Not Know the Names of the Victims." You should check that out. And then there's another video I created called "A Simple Strategy R. Kelly Can Use to Expose the Jane Does." You should check that out. Those 2 videos basically talk about the secrecy behind R. Kelly's trial, and you can watch those videos to see how they can easily be applied to T.I.'s situation. And finally, what can be done in the TIandTIny case if they decide to prosecute is that they can actually go with an anonymous and sequestered jury. We've already seen how that works And we've seen, if you've been following my channel, we've already seen how that works. And basically we covered that in some of the 2 videos that I've already mentioned. And there could be a 3rd video out there where we cover that. But, essentially we've already seen it, right? We know that they can ask for an anonymous jury. They could say that, hey, T.I. and Tiny, they're just simply too powerful of a couple, and we just want to make sure that they don't try to buy off any of the witnesses. We want to make sure that they don't try to intimidate the witnesses. They could also say that TIandTIny has internet followers who would intimidate and harass the jury if the names were made public. So this so far was enough to get an anonymous and sequestered jury in the R. trial. And I think the name of the video I made on this topic is basically the anonymous jury trial in R. Kelly's case won't matter, right? So that's another video you can check out. But essentially, an anonymous jury is a situation where the jury pool is basically pulled, but the prosecutors nor the defendants know who the juror members are, right? So there's something called voir dire, which is basically CNC, and it's a session where you get a chance to actually eliminate some of the jury members that would be selected. And what typically happens is that you get information about the jurors first, so you can do some type of research, and then going into that, you use your notes from that research to eliminate jurors as you go. But with the anonymous jury, you don't know who the names of the jury. You don't know the names of the jurors, so you don't get a chance to do any research. And because you don't get a chance to do any research, you're basically winging it when it comes down to the voir dire section. That's my understanding of it. If you guys have a different understanding of voir dire, questions and comments below. And then the sequestered jury basically means that the jury will be in a situation where they sit in a room, or they may even spend a night at a hotel, and they have no outside contact with the rest of the world. Now, while an anonymous and sequestered jury doesn't have anything to do with the secrecy of the actual witnesses, it does have a place in the overall secrecy of the indictment, because you're using secrecy to make it difficult for the defendants to defend themselves, right? And I've just, and with all the stuff I've just laid out, this is a legitimate play by the prosecutors, because the prosecutors have done it time and time and again, and they have case law which basically justifies having the secrecy behind the entire trial. And they could essentially keep the names of the alleged victims and potentially some of the witnesses secret. And in addition to that, they could also shield or put the entire case kind of under a veil of secrecy. And as you and I both know, it's going to be pretty hard to fight something that you can't see. And the secrecy component, or the secrecy aspect, in my opinion, is something that almost creates a definite win for the prosecutors. It's something that makes it extremely difficult for you to win, because you don't have any information, and then when you do get the information, you're going to be given the information at the very last minute, right? So that's pretty much it for this video. I just wanted to quickly talk about the secrecy behind some of these cases, and how TIandTIny can potentially end up in a secret indictment. They can end up with a secret trial, meaning they don't have any information, and they're going into this thing blind, and they're kept blind up until the very last minute. There are some there are some lines to be drawn. There, at a certain point, they do have to reveal the names of the victims. They do have to reveal some information, but as I said, this information would be revealed when it's too late, at the very last minute, right? So let me know if you think this could possibly happen to TIandTIny. In my opinion, I think it can, because we've already seen it happen. We've already seen this playbook be used. So let me know if you think it's possible that this could be used on TIandTIny. And let me know what you think about all this. That's it for this video. Please like, share, and subscribe. Questions and comments below.